Thank you, Gunda, for this kind introduction. I hope everyone can hear me. So first of all, since you already introduced the speakers, we can jump on the discussion. Lajla, I would start with you with a rather daunting task of explaining in a few minutes what the AI Act is and why it is relevant for foreign policy professionals.
Yeah, thank you. Thank you so much. And also hi to everyone in the room. And thanks for giving me like 2 hours to explain the complexity of the AI Act. No, but just joking. So what is the AI Act? It's actually an act of legal certainty for the future. It is actually a milestone for us to have now rules that apply to AI systems that are being placed on the European single market, where some ethical requirements have been discussed in the past. Now we have legal certainty about certain requirements. So this is really a big milestone. And what does the EU AI Act mean for practitioners? I mean, it's giving requirements for certain AI systems being to be placed on the market, both from the perspective of providers, so people or organizations that put AI systems into practice on the market and sell it, for instance, but also there are certain rules for the deployers of AI systems. So from FP practitioner's perspective, the EU AI Act also gives public sector organizations that use AI systems certain requirements to be fulfilled. So we have requirements for AI systems, both from the perspective of providers and deployers. But the good thing is not every AI system has to fulfill all requirements. The EU established a risk-based approach where we define 4 different categories of risk, starting with low risk, going to prohibited cases, and in between we have the high-risk AI systems that need to fulfill the most requirements, both technically and from an organizational perspective. So that basically, just to have a little bit more of a discussion, what I wanted to share, it is about legal certainty. It is about requirements that are needed to mitigate AI harms. That would describe the EU AI Act for me.
Thank you, Lajla. Yeah, just to elaborate a bit on that, indeed, these high-risk categories are those that are bound to be the most consequential for society. It includes public services, education, managing infrastructure, and so on. And these systems that are in these areas are subject to a particular due diligence regime precisely to make sure that they are accurate and robust. All right, so my next question is for Hans-Christian. I don't see him on the screen. Can you reveal yourself, Hans-Christian?
I think he still has problems to connect, so just give him a few minutes. He will join soon. Thank you.
All right, then Lajla, I'll stick with you. You know, when we talk about the AI Act in Brussels, there is this temptation of trying to see it as setting the international standards, much like the GDPR has been in the data protection field. And, you know, a lot of policymakers pat each other on the back talking about the Brussels effect. How likely do you think it is that we will see a Brussels effect for the AI Act?
I mean, I know this question pops up a lot, but maybe also just to give some context to it, the GDPR and the EU AI Act are different. They're not the same. So the EU AI Act is a product safety legislation, and the data protection, the GDPR is about securing the fundamental right of the processing of personal information. So in their nature, they're different, and in their scope, they're also different. So the GDPR looks on data processing. The EU AI Act defines AI systems in a very detailed, or at least in the attempt was there in a detailed way. So there's a big difference on that. And also like on a territory scope, if you look at the EU AI Act, it definitely focuses on products that are to bring on the European single market, so that it's not really necessary to look at where the AI system was being developed, but where it will be put into the market. So in that sense, there are some similarities and some differences between the GDPR and the EU AI Act. And in terms of the Brussels effect, I mean, the EU AI Act is not the very first legislation on AI systems. So I remember 2018-19, New York had a bill on AI systems in the predictive policing field. So in that sense, there is already legislation out there on AI systems. And most likely, the EU AI Act will inspire non-European countries to think about liability, product safety in terms of regulation for sure. But I don't want to say that in 10 years we have a fully harmonized global regime of how to regulate AI system. That's not going to be the case, I'd say, but we will see more regulation being developed out there, because we have seen that AI system has a lot of potential, but also some risks that in terms of the consumer perspective, but also in terms of the perspective of organizations using AI, there must be some safety requirements. And this is inspiring to not only European countries, but also to others.
Thank you, Lajla. So Hans-Christian, thank you for joining us. We were just talking about how the Brussels effect might apply to the AI Act. And I want to go back to that later, because I want to take a step back with you. And you know, since you are very hands-on in terms of how AI and data provisions should be sort of incorporated in foreign policy efforts. I would like a first-hand view from you on what do you see as the implications of the AI Act on foreign policy.
Thank you, Luca. Sorry, I had a technical glitch here, so joining a little bit later. The question is excellent because it brings us back to the double question of AI being an object of foreign policy. I mean, trying to regulate, trying to push for a Brussels effect, as you mentioned, or as Lajla mentioned. At the same time, also keeping in mind that AI is a fact and it's not going to go away. And the second part really being the question, how do we use it? I mean, AI as an instrument. Now, to be honest, I'm a big fan of the Artificial Intelligence Act. And I'm not saying that just because it took a lot of time to negotiate this piece of legislation in Brussels, but because it is clearly focusing on a risk-based approach, which I consider to be quite useful, to be honest. And turning to our day-to-day business, what I think is most important is that the AI Act is not going to keep us away from using artificial intelligence, but rather charting the way how we can best use it. And if a risk-based approach is the way to go, then I'm perfectly fine with that, because it is very similar to what we have been doing in the past as well.
Luca, you're muted.
Apologies, that was such a COVID thing to do. So just to follow up on that, we were just discussing before the difference between the GDPR and the AI Act, and the fact that the AI Act is risk-based. Now, from what we can see about discussions in other jurisdictions, there is a different risk appetite according to socioeconomic factors. So what is acceptable in a society might be unacceptable in others. What is considered as minimal risk in a country can be seen as a high risk in others. So when you have these discussions with, diplomats for other countries, how do you account for these different perceptions of risk?
Maybe I take the question, and Lajla, then you wanna follow up on that. I think that's something that, I mean, a different perception. Let me start this way. A different perception of risk might lead to a different application of the AI Act, right? So I think the best thing to do is really, and this is actually happening, is really to have a sufficiently large forum of practitioners, or to have the right fora to actually bring people together that are practitioners and kind of force them to come to, well, not necessarily consensus, but really slowly but surely agree on a common perception of what risk is. I mean, this is actually all about the application or the implementation of the AI. And you are right. I mean, that's actually an excellent question. What is considered an acceptable risk, or how a practitioner is actually assessing a risk of AI, for instance, the gravity of hallucination really becoming a problem in a public administration, might certainly differ from one organization to another. But I think the best thing here is really bring together those practitioners and encourage them to really make sure that their positions not necessarily converge, but get closer to each other.
Yeah, which I guess it's easier said than done. Lajla, if we look again at the experience of the GDPR, there is also a discrepancy between what is adequate data protection standards, and we have seen with the Schrems ruling that even with Europe's closest ally, it has been difficult to come to terms and get a shared understanding. So, and data protection has been around for quite some time, whereas AI it's fairly new. So, what challenges do you see in reaching this consensus? Well, in Europe, but also beyond Europe, because we are talking about international dimension here.
Mm-hmm. So maybe as a disclaimer, I'm a rather optimistic person. So in terms of have we learned from the GDPR fatigue, I'd say yes. The EU AI Act is actually quite helpful at tackling some of the trauma that has been felt around the globe around the protection of personal data being a barrier to innovation, because it's not true, and we can make better, and the EU AI Act tries to do so. So just to give everybody a basic understanding, it's not like you read the EU AI Act and you know on how to apply and bring the requirements into practice, but rather the EU AI Act asks sanitization organizations to then define on how to fulfill the requirements from a rather technical and organizational point of view. And that's actually in the making right now. So the standard setting organizations are working on the standards right now that will be helpful to determine whether or not and how you can meet the requirements. So this is still ongoing, and I have I'm hopeful that it will help to kind of set a harmonized interpretation on how to fulfill the requirements, at least in the European sphere, but also there are already international standards out there that companies and public sector organizations can use in order to make a better risk management system available, or actually try to, let's say, bring human oversight into practice. So from that point of view, I'm optimistic. However, we need to say that there aren't the right standards there yet. So there will be published, it is said 6 months prior to the requirements coming into force. which is not enough time for all organizations to feel equipped to apply them. So especially regarding your the question beforehand about the risk, if I look at the public sector and the foreign policy practitioners, these are people that are very risk averse for very legitimate reasons. So they want to make sure that the work they do serve the common good in the best ways. And I do think that they need support in overcoming too much of a risk-averse attitude, and they need to support on how to apply the standards in a way that it is efficient and it doesn't necessarily hinders innovation, but also fulfill the requirements of product safety we have now. So there will be some sort of support needed for the public sector, especially. And this I see as a challenge in the upcoming years.
Thank you, Lajla. And I'm afraid to tell you that everyone who's involved in Sense Analytic recognizes that these standards will be late, and it's probably going to be a partial delivery. Hans-Christian, before I give the floor back to you, I mean, technical standards are, of course, very important when we talk about technology. But I'm more interested in the political discussions, and especially since our audience are foreign policy professionals. There are so many forums talking about AI global governance. We have seen the Global Digital Compact at the UN level. There is the OECD, the G7, and whatnot. So, you know, what is the EU role? EU meant as EU AI office, but also EU member states. How can the EU play a role in this discussion? What is the, you know, the strategy to engage with international partners? Should we focus on like-minded countries, or should we try to be more inclusive, which might also mean that there are more different views on the table?
Well, Luca, that's quite a big chunk of questions that you are shuffling on my table now. Let's see how I can tackle them. I mean, the first and the positive thing is the AI Act is there, right? And there is a whole set of structures around it. So I'm not really worried about not having the right fora to discuss things. I honestly think that the AI Act, and the AI Act is not the only instrument, right? We have the Council of Europe things, we have UNESCO, etc. So there is a sufficient amount of regulation present that is being discussed. Obviously, it's never finalized, right? It's going to be a discussion that is ongoing, and of course we need to talk to everybody, because this is a disruptive technology that doesn't know any borders. So it makes a lot of sense to always remain in contact with those that are using it. But again, I want to make the point that on a technical level, even diplomats would depend on people that provide them with the technology. Usually that would be the IT departments, right? And those IT departments, they have a technical responsibility. They have to make sure that the risk-based approach is being firmly integrated in the provision of certain services. And this is happening every day. So I'm not really worried about this. The second level is probably the one that is most complicated. That is the level between the international negotiations and the technical things. And that is the attitude diplomats or government officials will take in their usage of AI and data technologies, right? And for this purpose, we actually created the AI Charter in the Ministry of Foreign Affairs, which is actually a guiding element that would always make sure that, Luca, you want to use AI in a negotiation, make sure that you pay attention to ABC, coupled with sufficient amount of training and literacy to make sure that you really know what you're about to do. And this is actually the middle layer that I consider to be most important right now at this point in time.
Thank you, Hans-Christian. Going back to you, Lajla. Usually when we talk about the Brussels effect, we essentially mean two things. One is that companies tend to adopt the EU standards and make it the standards they also follow in other markets because it's more convenient for them than to create different products for different markets. And the second one is that the EU laws inspire other jurisdictions. And I think with the AI Act, we are seeing that in Brazil, in Colorado passed a similar law. So which of these two dimensions of the Brussels effect do you see the most likely to leave a mark?
I mean, I guess with the first one, if you boil me down to one answer, I see that with the product safety approach we have with the EU AI Act, we encourage companies to think about the organizational and the technical changes needed in order to provide and deploy AI systems in trustworthy ways. So I do see here a lot of actually advantages for companies that nonetheless, whether they are asked to do so or they want to do so, adapt to these requirements. So I do see there's an advantage for companies to rely on these requirements, not only within the EU, but also outside the EU. With the Brussels effect in terms of inspiring other countries to follow the same approach we have in Europe, I am not sure if I can make a empirical based guess on that already, because the EU AI Act came into force, but it's not into the effect. So we are still there's still a need for us to think about the national implementation of the EU AI Act. Like in Germany, we have to define the Market Surveillance Authority. We have to find regulatory bodies and agencies. So this is still something we have to do. And then again, we will see on its effects in the later stages of the enforcement process. So any other countries that might be felt inspired should at least wait a little bit, from my perspective, to see how the EU AI Act is really coming into force from a practical sense. So I don't expect countries to follow immediately, but the next couple of years, 2 to 5 years, will be very interesting to follow.
Indeed, and at the same time, you know what, the EU strategy here was also to be the first mover in this space and therefore become a model to follow for others. What about from your perspective, Hans-Christian? Do you see other jurisdictions, you know, taking interest at the AI Act? Of course, AI governance is something a lot of people are looking into across the globe. So when you engage with international partners, you know, what are the burning questions that come up, and you know, what are your lines in terms of why there should be alignment with the AI Act?
Thank you, Luca, for the question. I mean, there is a short disclaimer. I mean, when we are talking to colleagues internationally, that's most of the time the practitioners, right? That's the people that are supposed to either prototype or develop artificial intelligence tools for, let's say, diplomats or for government officials. So that's very much those people that have practical problems. And I think what they would typically tell us is that, okay, we understand the technology, that's fine. We know how to set up a model server, vector databases, to find the right model that would serve the purpose. That's okay. And we can prototype quite a number of things. But how do we actually do that when we use it for productive purposes? I mean, how do we roll out an AI chatbot or an artificial intelligence co-pilot, for instance, for a Ministry of XYZ, Ministry of Foreign Affairs? And that's really the main question here, isn't it? Because then the AI Act really kicks in, and you are back to a situation where you need to think about risk, transparencies, transparency, disclaimers, life cycle management of artificial intelligence. And that's the kind of questions where we have only partly answers to those questions. I mean, we quite well understand that a risk-based approach also in terms of the Artificial Intelligence Act can be implemented. Lajla, you mentioned market surveillance. It's a market surveillance thing, right? Isn't it? But then in terms of managing the life cycle of an AI system, that's more complicated. I mean, how do you make sure that your system that you train, let's say, every 2 to 3 weeks with fresh data is still producing meaningful results, or is producing results that are at least as good as the initial version that you were publishing? And how do you make sure that a diplomat that is focusing on negotiations really understands that problem? And that's a technical or organizational / technical thing. Now, on the broader, let's say on the more broader meta level, all those questions about ethics, about user protections, etc., I think we have quite a good understanding about what could be done and what should be done. Also drawing experience, or also drawing from previous experience with similar pieces of legislation.
Lajla, any reaction to that? I think Hans-Christian touched on very interesting points there.
Yeah, I mean, in terms of the experience with product safety approaches, just to make that clear that actually there is some rooms to fill from a political perspective, because with the product safety approach of the AI Act, we have like two major paths on when an AI system might be considered high risk. It is already part of a harmonized product safety approach. So it might be like there might be an AI system included in a product that is already covered by a product safety approach in terms of, let's say, toys, for instance. So then you have a high-risk system, but then again, you know what your conformity assessment should look like and who you should talk to. But then we have also the second path of standalone AI systems that might be high risk because they are being applied or provided in fields that are very sensitive. And for those cases, I do fear that we don't have as many experience as we think we have or need actually, because if I think of AI systems in the public sector, there is to this date no registry in Germany where all AI systems are being publicly listed, where other public agencies, for instance, can feel inspired on how to use AI and also can feel inspired which AI systems are safe to use. So there is like those standalone systems within the public sector. There's a lack of experience on how to apply product safety rules. And there we need to have a deeper look into, and policy can actually help to enhance the uptake of AI systems in these fields by providing compliance support, for instance, because we don't have to ask the big companies on how they apply the AI Act, because they have a compliance department of over like 200 people working only solely on these topics. But the public sector, the foreign policy sector, needs support in that regard.
Thank you, Lajla. You want to react to that, Hans-Christian?
Yeah, thank you, Lajla. This is obviously a very good and well, very relevant aspect. Maybe two very quick thoughts on that. The first one is that at least in Germany, every ministry has a data and AI lab these days, which is extremely helpful in bridging the gap between AI practitioners, those that are supposed to use it. I mean, I call them internal customers, and if the organization has an IT department, the traditional IT department. So this is really helpful. But at the same time, you're right, while we are having, for instance, in Germany, a system that makes sure that we are talking regularly among practitioners, sharing expertise on a weekly level, this is probably not made sufficiently transparent. right? So while a lot of conversations are happening inside or within public administration, this is not always made public. But with these two comments, I would still support your point that nobody to this date has found the perfect solutions or the perfect solution to set up a robust AI governance in practice for those high-risk systems. So that's definitely the point where you are right. And this is something that is really on quite a lot of people's agendas, to be honest, to really prove that also in a production ready on a productive system or in a productive environment, you can really maintain those standards as they are prescribed in the AI Act or in other relevant documents.
Right. Mindful of time, we only have a few minutes left. I'll give you 1-2 minutes for some closing remarks. And so, what is it that foreign policy professionals should keep in mind about the AI Act in their daily work? Lajla, you want to start?
Oh, so what is it? Maybe last remarks. The UI Act is also a mindset thing. I mean, I don't want to do like bullshit bingo here, but really it's about the mindset we have when thinking about the UI Act. It does help us to increase regulatory certainty. And this we need in order to make the best of AI use in the public sector, because I see a lot of potential in using AI systems. We already have discussed this in the morning, but I do see the need of support of public sector organizations. I do see a need for compliance support in any sense by public sector as such. And I hope that with the AI Act, we enable lawful AI systems. But then again, this is not enough. If we talk about trustworthy AI and common good AI, we also need to take a step back and think about the intended purpose of these systems. So not every efficiency increasing system is a system that enables common good benefits, but rather we have to take into account the intended purpose of these systems, the people that might be affected, and the way the systems are being developed. And if we take this bigger approach, such as with the Charta Hans-Christian mentioned, it can enable us to use AI for the common good, but only on the basis of lawful AI. So maybe this would be my last remarks. I know I didn't answer your question fully.
Hans-Christian?
Thank you, Luca. I try to be very, very precise here. I think the most important elements are, first, let's not shy away from artificial intelligence. It's there, it will be used, and we should use it. We should use it responsibly. The second one, the Artificial Intelligence Act, is a piece of legislation that was widely consulted. The consultation process was quite intense, I feel. And it's there, and it's a piece of legislation that is timely, that is useful, and that still remains within traditional sets of regulations to a certain extent. And I mean, quoting market surveillance. The third one is that it's all about making sure that those that are developing, especially standalone artificial intelligence systems, and those that are supposed to use them, really have a common understanding. I mean, really know what the systems can do and how the systems should look like. So for me personally, if I'm looking, I'm talking quite frequently with our IT colleagues. I think it's all about having this conversation. What is this solution supposed to do? And then explaining people the risks and the opportunities. The documentation, the risk assessment, etc., etc. That's then obviously something that needs to be mainstreamed in the regular software development process. But that's something where diplomats are probably not best equipped to do that, where they could only be, well, those that are being interviewed and consulted. But for me personally, it's a matter of taking that step from prototyping something to a productive use of artificial intelligence.
Thank you very much, both. I'm afraid we ran out of time, and yeah, I think we had a very interesting discussion today that shows how much ground there is still to cover. Unfortunately, 40 minutes, but even 2 hours, I fear, would have not been enough. But indeed, it's an important discussion to have. So thank you both for your time.
Thank you, Luca, for the great questions.
Thank you, Luca, for moderating us through.